How does it feel to have changed the world?
No. I would never characterize it as changing the world.
Amazing. At the same time, it feels a bit frustrating to have to celebrate this as a win.
So Guantanamo Bay is essentially a high-security detention facility in Guantanamo Bay, Cuba. It is controlled by the United States, and it was established in 2002 after the 9/11 attacks. Its primary purpose is to host high-value detainees. It is controlled by the United States, but it's not bound by US law, essentially.
People detained, to my understanding, they're often held arbitrarily, I think is the word used, because it's a long period of time. There's no real sense of when it's going to come to an end.
It's been named the most notorious prison in the world. It is a site of detention of prisoners that were captured by the United States in connection with the quote-unquote war on terror.
They would be transferred to black sites initially. There were some in Poland, Romania, Afghanistan, I believe, and then after a while, some of them, most of them, would be transferred to Guantanamo to be held there.
Who the individuals were who were captured, and whether they necessarily deserved or were associated with any organization like Al-Qaeda in a way that would necessitate their capture is very up in the air.
These black sites are basically under the radar and meant to be specifically outside of a legal framework.
We know that during CIA detention, a lot of Guantanamo inmates were actually tortured while they were questioned. Mr. al-Nashiri is alleged to have kind of masterminded the bombing on the USS Cole in 2000. He was 2 years later captured and then held in CIA detention for about 4 years. He was tortured while he was in CIA detention during that time. And after the CIA detention, he was transferred to Guantanamo.
The legal process that Mr. al-Nashiri has been through has been quite complex. It's not been very steady. After he actually arrived in Guantanamo, he had initial charges for war crimes brought against him, I believe in about 2008. There was a brief period where they were dropped in association with then President Barack Obama's kind of freeze on all proceedings against Guantanamo prisoners, and then brought back in 2011.
He has mainly been put through military commission trials, and his rights to defense, you could say that they have been denied, or they have been minimized at least, because he has not had a right to a proper defense. He has not had the right to proper advice on his legal situation.
Because Guantanamo was first used as a detainment center in the context of the war on terror, there seems to be a lot of pushing of what actual legal conditions are in the name of the war on terror, in the name of national security.
I think that when you capture someone you think is guilty of a crime, he must be brought before a court in as expedient a manner as possible. And this continued detention of al-Nashiri is problematic.
Essentially, has gone through the whole torture concept, which was developed by 2 psychologists for the CIA.
This creates an ambiguous situation regarding the validity of his testimonies, whether he's obtained under torture, whether he's obtained by his free will.
The Convention Against Torture and several other international legal instruments specifically make reference to how torture-tainted evidence are not to be admissible in any proceedings.
The prohibition on torture is of a categorical nature, so allowing torture-obtained evidence in any part of the proceedings would go against the standards held by international law.
On May the 18th, there was a decision by the military judge that all evidences obtained through torture were not admissible in a court of law during the trial, but that, however, specifically for US versus al-Nashiri, that these evidence could be used in the pre-trial proceedings.
Essentially, the Judge Acosta, the military court, was interpreting some domestic United States legislation and came to the conclusion that evidence that the government had got by torturing someone could be used in court at a certain stage of the proceedings. That might sound technical, but in effect that's saying, yeah, you can torture people and you can use what they say and use it in courts. And the effect of that is, I mean, I think straight away you can see it perhaps incentivizes torture, or at least it justifies its use.
The point of prohibiting torture evidence is to eventually prevent the use of torture.
So the prohibition of torture is a jus cogens norm, so it's non-derogatory, not even in times of a public emergency. And that obviously means that evidence obtained through torture can never be used at any stage of any proceeding. And if we now say it is allowed to use evidence obtained under torture at the pre-trial stage, it essentially risks to weaken this kind of foundation of core international rights and non-derogable rights. And it essentially risks that this whole foundation collapses.
Presumably it's partly just the problem that people say stuff when they're tortured, which they say to stop the torture.
Yeah, you want it to stop. Absolutely, people, yeah, and that's why the evidence that you get by torturing someone should not be relied upon. It just isn't even reliable in the first place.
So an amicus is basically a written submission to a court containing legal arguments or legal recommendations.
It provides not necessarily expert evidence, but it does provide the judge with an additional amount of information with regard to the specific topics that the case is considering.
The amicus has tried to comprehensively survey the principal sources of international law. So that is international treaties, regional treaties, international case law, regional case law.
So I initially was looking at secondary sources from anywhere in the world, again, journal articles to blog posts, Twitter threads.
To sort of track down quotes and passages that would reinforce the position that we were taking.
I assume using that angle will also help us.
I looked at the UN Working Group on arbitrary detention and on the reports of the Special Rapporteur on torture.
I had to research the decisions of different UN treaty bodies. So there are different human rights treaties and there are bodies established to monitor their enforcement and sort of provide guidance as to, what the different rules mean.
At first, I was tasked with looking at the inter-American human rights system, as well as the African human rights system.
And then the second week, we were tasked with looking at common law jurisdictions and looking at cases that have to do with prisoners' rights and torture-tainted evidence.
And as part of that, I think we're going to be looking at domestic court decisions. So maybe we can also talk about how the standards at the international level interact with different jurisdictions, different common law jurisdictions. So we've got, America, Australia, and so on.
Then another task of mine involved looking at case law of international tribunals.
Have we also found anything from the ICTR and then also the Sierra Leone tribunals?
And towards the end of our work, I was looking at the domestic case law of England and Wales and Canada.
I need to add some more to the Canadian case law because a lot of the ones I found were from like 100 years ago.
I looked into the prohibition of torture in the military justice context.
I looked a little bit also at what the International Criminal Court had to say about it.
I looked at a lot of European Court of Human Rights cases, but they hardly ever talk about the pretrial stage per se. There were actually a lot of cases, and I worked with 2 other students on that, and we divided up the work.
We produced a very long document that we submitted to the research team afterwards.
And then finally, I also looked at US case law on the adherence to international law.
We looked at cases also in Spanish as well as in French. Part of the strength of an amicus can be in how much kind of information it can look at, right? And here we had a very international and comparative outlook, and that was brought in part because people came from such different places and could understand, brought an understanding of the legal systems and, the different rules.
They always emphasize in any proceedings. So I feel like combined with the categorical prohibition, that is kind of like a strong argument that it's just that no differentiation should be made between the pre-trial stage and the actual trial stage.
We edited, we looked at footnotes. It was very important that we were very, very accurate with what we were saying. There could be no small errors because that would have undermined the credibility of the entire amicus potentially.
I'm not sure how much the others worked on this, but I did spend quite a while sending back and forth drafts, just making sure that we had the final bits done and that the font was correct and that the citation style was something that they would appreciate.
Yeah, we were under quite a lot of time pressure.
Yeah, it was a lot of work.
I said to myself, it's fine, I can catch up university work later.
Yeah, after uni, after my classes, I started to work on it, also sometimes very late at night.
It was the first time that it felt like actually working and actually having to commit to deadlines and commit to deadlines that really felt like they mattered.
At uni, you're often, you're reading books, you're watching lectures, it's interesting, for sure, but it was great to have something real, like a real life event, a real life case, and we knew that what we'd find was going to be used, not in a textbook, but in real life. So that meant that there was a lot of pressure as well. We couldn't make errors. We had to work hard, but I think that was the motivation for all of us, is that this is serious, and you can make a difference.
So yeah, maybe not going out to the pub for a couple of weeks, but it was definitely worth it.
These were people I didn't know at first.
I didn't know anybody before I started.
I had just joined the legal clinic at the time. This was the first thing I had done.
I was friends with some students involved because they were fellow politics, philosophy and law students. I didn't know some of them. There were some people that don't even do law in university.
It was great to work with that team especially because we all we kind of became friends, and it was great to just talk to people studying on the same course and being interested in the same subjects.
Like, I know that it's not ideal to not have a specific trial-related quote or whatever, but I think the weight of our findings, especially to do with any proceedings, I think that should be quite persuasive.
There's not one quote that sticks out, but the breadth, the plethora of opinions, of statements that showed that the use of torture evidence is prohibited regardless of what stage of the trial you are, or regardless of what kind of court you're in. So the amicus was submitted in November, and at the end of January, the Biden administration announced that they would no longer pursue the use of torture evidence in the trial?
Since, I have to be careful, I don't want to misconstrue. I think since then the US government has changed their position. So I'm not sure if the amicus directly led to it, but I think it had an effect. And since we filed it, since it was submitted, the US government has essentially said, look, we're not going to argue that point. We're not going to argue against the idea that evidence obtained under torture is inadmissible. We accept that it is inadmissible, even at the pre-trial stage. So it worked.
How does it feel to have changed the world?
I wouldn't. It's been fantastic working on this, and it's been fantastic actually being involved in this case. I would never characterize it as changing the world. This sort of submission goes hand in hand with the work done by countless organizations which were working towards just the ability of fair trial proceedings to be properly achieved in this instance, and just being part of what is hopefully a deluge of information that was sent to them to say, you can't be doing this, is special in its own way.
To see your work contribute to this very significant turnaround, both for the case of Mr. al-Nashiri, but also for human rights law throughout the world, is really rewarding. It's really incredible, and it honestly gives you a bit of hope.
Amazing that the Biden administration took the right course of action. At the same time, it feels a bit frustrating to have to celebrate this as a win. The fact that we have to celebrate that it accepted an obligation that it clearly has under domestic and international law seems a bit, frustrating. That's all I can say.
Can we change the world? I do think we can. The work of individuals and groups has consistently been highly important in changing the way that international law is considered, domestic law is considered, in the way that we think about justice and fair rights simply. I think the work of individuals continues to be incredibly important in relation to Guantanamo Bay and the ability to properly achieve justice for the individuals who are still held there and who have been held there in the past. And hopefully that work will continue.
I think the amicus has definitely shown me that it sounds very cheesy and cliched, but anyone can make a difference, and that it doesn't need to be in some gigantic, world-changing way. It can just be working within your sort of university or your community and participating in things that pop up, making yourself available and doing what you can. So especially the fact that, we're based in London here. I'm not even I'm from Australia. I'm here in London, and we've helped settle a matter of law in the United States. It's really hard to sort of make sense of, but I think it's a testament to how our world is very interconnected today, but also that we have to sort of make the most of that and reach out to people, work with people, and do what we can.
I would say that changing the world isn't really about big impacts, but about small incremental changes that we make and that we push for. And yes, and I think when we each commit to making these small changes and trying to convince others to make small changes, then we actually sustainably change something in the world. It's not about one person who does one big thing. That's also important, and it mobilizes a lot of people and it inspires people, but in the end, one person making one big change isn't gonna have a sustainable, long-lasting impact on the world. It's about each and every one of us.